So if you've got a question, raise your stick up in the air proudly and Olga will come pick it up. So you got a duplex probably, or you have a multifamily of some sort, because it could be like in the same house, like you rent out rooms, that sort of thing. It's the same problem. And so if you have a situation where either a non-tenant, it could just be your neighbor, or your other tenant is potentially causing harm to the to your current tenant who wants out, it comes down probably in the Texas Realtors lease to section 18 of that lease. And what section 18 says is in the event of a defect on the premises that materially affects the health or safety of an ordinary tenant, you got to do something about it. And if you can't resolve that defect, whatever it is, it could be that the ventilation system brings all the weed smoke into the unit. If you can't stop that, then you've got a problem. And so, yeah, they might have good cause at that point to terminate under a different section of the property code. It's 92.056, which talks about things that you do have control over to some degree, but are unable to resolve. And that also works for the tenant. You know, if the tenant can't demonstrate what the defect is, how can you resolve it? I had a case similar to that. It was more of a hypochondriac sort of situation where I think the tenant like expected there's something to be wrong. She insisted that there was a defect that was causing her medical harm, okay? The landlord sent out more than one person to check. They found no source of a smell that would lead to this harm. They found no evidence of the smell. They had no idea what it was coming from, and nor could the tenant identify the source, nor could the tenant precisely identify what this odor was. But she insisted, I gotta go. And so she left. And so we resolved the matter later, but ultimately that tenant owed damages. And what we resolved were the damages that she owed for just walking away from the lease. So part of 92.056 is that the tenant has to establish what the defect even is. In this case, it's smoke. Can that tenant prove that marijuana smoke poses a material threat to her safety? No. But to her health? Maybe. And I don't know what effect it's having, but she would have to prove that it's posing a material threat to her health. If she can, right? For example, if she got drug tested and said, I have never smoked marijuana, but it's in me, and I don't want that in me, that's a technical problem for you, the landlord. So typically, a lost or broken air conditioner is not a casualty event. Unless it was struck by lightning, or unless it was damaged in a fire, or some maybe hail damage just destroyed, it's usually not a casualty loss. It's just upgrades or maintenance. So for regular maintenance, like when the toilet breaks, or where there's a leaky something else, or an electrical fuse goes out or something, you might be able to tell I'm not very handy with home repair. But something happens that's not a result of a casualty loss. The rules are different. Now you're just under regular repair rules where the landlord is required to act with diligence. And I'm glad you brought up air conditioning, because air conditioning issues come up all year long. But when does air conditioning pose a material risk to someone's health or safety? In February? No. In July?
Yes.
Yes. Now, what's the rule of thumb when it comes to air conditioning? Because you're going to have different tenants say different things. Basically, it's a rule of 20. If outside it's 105 degrees and your unit cools down to 85, you are right at the line. You are right at the line. Guess what? Nobody's getting a heat stroke at 85 degrees. They're not particularly comfortable, but that is not a material effect on health or safety. Just because they're sweating a little bit doesn't mean they can terminate the lease. Now, if it's 105 degrees outside and it's 95 degrees inside, that is a potential health hazard. That's a legitimate problem. And you must act with diligence. And it doesn't matter that your insurance won't cover it, you must repair it. Because now you have a defect on the premises that materially affects the health and safety of an ordinary tenant. But if it's just a matter of it's not working well and it could use a boost, there's various things you could do without replacing the unit. You could add a window unit. You could add some Freon or just some maintenance that maybe lowers the temperature a little bit. And then you just wait until July and August pass by. But the rule of 20 essentially establishes that it's not a dangerous thing. And it's okay because 105 degrees in Texas is not common. Right? And so we don't build our houses and we don't have our units necessarily to deal with heat that intense. Might we over the next 20 years as climate changes? Maybe. I don't know. I'm not a climatologist. But right now, the rule of 20 still applies, and you can use that as a rule. It's 100 degrees outside, it's only cooling to 80. That's still okay. They might just need a window unit, a little extra something, a temporary fix to get them through the hottest part of the year. Right? And so maybe later you can talk about replacing the whole thing. But if the unit is at least doing that, it should be fine. They are not in a situation where there's a material effect on health or safety. What the code says is that the landlord and tenant may make arrangements, which means they have to agree on the amount. And so, yes, you could evict on that basis. But now you're going to have a third party, a judge, who's going to definitively say yes or no. Yes, so this would be termination by default. And so in this case, somebody has done something wrong. They have violated the pet provision. And so yes, now typically in these situations, if the tenant is paying rent on time, every time, what we suggest is a 3 strikes policy. 3 strikes. So let's say the only violation is this pet. So they have an unauthorized pet. I would send a notice. You are in violation of the lease for having a pet. Please remove the pet within the next 5 days. And then on day 6, you go and check, and there's Scruffy, this tail wagging, real happy, and say, oh, well, I asked you to get rid of it. Here's the second notice. Please remove the pet within 5 days. Or I'll be forced to evict. And sure enough, you come back a week later and Scruffy is still there. You say, this is the final notice before I terminate the lease. And the reason that we want to do 3 is because this happens all the time. You show up after just 1, and the tenant shows up in tears and says, Your Honor, I got rid of Scruffy, and it broke my heart, but Scruffy's gone. And so I did what he asked, and now he's trying to evict me, even though I pay the rent on time, every time. I'm literally the world's best tenant. They'll say it all the time. And the judge might agree. And it's like, you got rid of it? And you never know, right? And so if they fix the problem, even though it is a violation of the lease, and even though it does allow you to terminate it, 1 time might not be enough. But if you can demonstrate to the court, I gave them notice after notice after notice, and they still wouldn't do it. They certainly didn't pay any additional pet deposit. They certainly don't have a medical basis. Watch out for that emotional support animal line. That happens a lot too. And they never heeded any of my written warnings, nor made any attempt to work things out with me. And so because of that, even if they got rid of Scruffy after the 3rd time and the notice to vacate, I can't trust them with this lease not to violate it again. And so a 3 strikes and you're out policy is appropriate in that situation. That's what I would recommend. Notice, notice, notice in order to build a stronger case. Next question. If you had one, you have to maintain it.
Okay. But if there was never one?
If there's never one, you don't. But if your tenant asks for one, put one.
Okay.
Yeah. If you don't have one there, put one.
Okay.
Yeah. So whether it's mandatory or not is different than whether it makes sense, right? And so if you're saying, well, I don't want to have to, obligate myself to protect my house in the event of a fire, it's probably a good rule of thumb to do it, just in case. Make sure it works. You don't have to install a sprinkler system, but it's a small thing that you can do that might go a long way to save you some money.
Okay.
So there's a couple of ways to prevent loss. Number one, my most effective way is to evict faster. The moment they stop paying, I have a 137 policy. I'm not going to go into it, but the 7 says if you haven't gotten 100% of all rent and fees owed within 7 days of a due date, notice to vacate, get rid of them. Because you've got a security deposit that only goes so far. However, if you're in a situation where it's not rent so much as they cause damage to the property, the real question is, when was that damage caused? One way to prevent damage, I get landlords who come to me sometimes and say, Ernie, I could not believe what I found. I gave them the keys back in 1998, and when I went last week, destroyed. I'm like, well, come on, guy. I recommend every 12 months, no fewer than 2 inspections. Right? Go look at the property. What's the plumbing doing? What's the ceiling doing? The floors, the walls, the appliances. You're going to find stuff if you're looking for it. But if you're not looking, stuff's going to get taken, ripped out, torn up, and broken every single time. One way to prevent that is to be there more often. Now, if it happens with, in a period in between those diligent inspections, unfortunately, there's not a lot you can do. Yeah, I tell people this all the time. Look, you can't reason with unreasonable people, and you can't stop criminals from committing criminal acts. Those are rare, they're not common, but when they happen, some people are just not findable. Sometimes they commit fraud and the name they used in their lease and the application wasn't real in the first place, but even through a diligent search, you couldn't detect that. It's not till later you find out it was all fraud. That happens, and unfortunately, it's one of those negative parts of the business. Yeah, but to get ahead of it, inspections, thorough application process, and then evict faster. Evict faster. That's an excellent question, and it's something we get all the time. I went, and either A, the tenant refused to allow me to go in, or worse, I went and my key suddenly didn't work. Or I went, and while I was there, that tenant called me a mother this and a son of a that, and literally kicked me out of their house, said they were calling the cops. What do I do? Well, number one, you gotta look at your lease. And a good lease is going to say you have the right to enter at a reasonable time and in a peaceful manner to make repairs, conduct inspections, and yada, 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 yada. If you use the Texas Realtors lease, that's section 14B of your lease. Right, we deal with this provision all the time. If your tenant violates that lease but has paid the rent, guess what? That's strike one. You send them a written notice and say, on such and such date, I was here to make a repair. You denied my lawful entry. I'm coming back on date X. And then you show up on day X and they do the same thing. And this time, they're standing at the door and say, you are not coming in. I already told you. Say, no problem. And you walk away. You issue that second strike. On such and such date, I am coming back. And if you bar the door or prevent me from entering, my only option will be to evict. And sure enough, that time they got the shotgun. All right, I told you, are we gonna dance? And you say, we are not going to dance. And you walk out, and the very next thing is a notice to vacate. Right, this happens. And so you can't let the tenant take control of this process. This is a tenant that's not a good fit. They're going to cost you money. They are telling you point blank, they don't care about that provision and they have no intention of following it. That's somebody that has to go. You always need their permission.
Well, yes, of course.
To pull credit.
Yes, they have to sign the authorizations for you to do that. But
you wouldn't be able to charge them for that. If they're providing it through, if they provided you a credit report and you want another one, be prepared to pay for it. I don't know what your lease actually says about prohibited conduct.
It's the Texas Realtors.
Okay, so if it's a Texas Realtors lease, there is a specific section on prohibited conduct, and I don't remember off the top of my head what it says specifically about defamatory statements. But certainly, if she is not following the law, and there is a provision in there that says you have to follow the law, and defamation is against the law, right? It's a civil claim, but it does violate the law for her to defame you. You could use that as a basis if she had not ceased and desist the defamatory statements that she was making. Now, I don't know what those statements were, and one, I'm just going to give you the quick defamation class from law school. One absolute defense to a claim of defamation is the truth. And if the things she said about you were truthful, that's not technically defamatory. But if they were untruthful, and she knew they were untruthful, but she just wanted to say them to hurt you, that's a violation and should be addressed with notice. And if she doesn't stop it, it would likely be a valid cause for you to terminate. So in this case, there is a family in place who signed a lease in August and now has found their dream house. They've either bought it or they're about to close. And so they want out early for this reason. So this is one of those where you bargain for a buyout. Let's talk about what the law says when somebody, because they could just leave. They just, here's the keys, we're walking, right? And that's probably what they're going to do if you don't reach a settlement. So part of you reads the lease that says, well, I'm going to accelerate it all the way to the end, which yes, you absolutely have a right to do. But you also have the duty under the law to mitigate your losses. So along with accelerating all the way to the end, the moment they leave, you have to go and find a new tenant. Whether it's this other family or somebody else is not what matters. You have to find a new tenant within as quickly as is reasonably possible. So let me give you a few scenarios. Let's say they tell you we're leaving at the end of December. It's November now, we're gonna leave at the end of next month. We're gonna pay November and December rent. So that gives you an opportunity to go look for a new tenant. But let's say you don't find a new tenant until January 20th, okay? And sure enough, they left December 31st, turned in the keys and left. Well, in this scenario, you may have hired a realtor to help you list the property and paid a certain amount of money to them and then lost 20 days of rent. But that's it. Once you have that new party in place, you have mitigated your damages and the rest of the rent is not due anymore. You can charge them the reletting fee, which would be probably what you paid the realtor to list it, and then you can charge them the 20 days in rent. And if you've got a security deposit that covers that, and assuming no damage to the property, they owe you just the 20 days of rent. And that's it. And so if you know you've already got somebody who's a good candidate who can replace them, you can make a calculation and figure, well, because we have to mitigate our damages and we have to put somebody in, and they're gonna come in quickly, and we can reduce our losses, we can make a deal that doesn't include the full value because we're not allowed to charge the full value once we've mitigated our losses. Once we have that new person in place, the damage cuts off and you cannot charge them anymore. So think about those as possible things. If the new family is a good family and they have the money to pay the first month and deposit, you may end up with no losses. If you were not damaged, you can't collect termination fees, no. So you have to be damaged. And so by default, you're damaged all the way through the value of the lease. But if you find, the sooner you find your new tenant, that damage shrinks only to the amounts that remain unpaid. Right? And so once you have that new person in place, you have mitigated your damages and you no longer have those losses. If you write a termination agreement that makes sense for both of you, and it's too little for you, that's unfortunate. If it's too much for you, great. it works. So you have to find a number that makes sense, even if it's a little less or even if it's a little more, but that makes sense to both sides. And that's what I would recommend. If you know it'll take you 60 days to put a new person in place, and it's gonna cost 1 month for your reletting fee, well, you better have 3 months worth of rent to cover all of those losses. And that's the way you calculate it. Sometimes it's easier, sometimes it's harder. If this were June, no problem. You're gonna find new people really fast. But in December, it is harder. You always can take the rent from the security deposit. I just don't ever recommend doing that during the tenancy. So let's say, for example, you got someone who's saying, I'm leaving at the end of December. It's currently November, I'm leaving at the end of December. Just apply that security deposit. You can keep it, I'm fine. I won't worry about it one bit. And then we'll move out. Wrong. What you do on day 2, if they've said that, notice to vacate, you gotta go now. Because they have not paid rent, and the chances of them paying it, because remember, you have no idea what damages are gonna leave upon move out. And so you've lost all of your security by accepting that deal. You're allowed to, it's just not very wise. I would say, if you do that, I will evict you. I say, why are you evicting me? I'm leaving. Because I want a judgment to recover all of my losses, which you will increase by doing this. Another thing, your lease already addresses this matter, and it is a violation of the lease and state law for the tenant to withhold the last month's rent. In fact, you could request up to 3 times damages for that, so don't accept that. Tell them no, that's not allowed. You will get hit with an eviction, and you will be sued for the losses that I will definitely incur from this very bad deal. I would enter into a termination of the original lease and then just start, an agreed termination of the original lease and then start afresh with the new lease. And then what the new lease could do, if, for example, you're raising the rent or you're raising the security deposit, you can refer to it and just say, I continue to hold the security deposit. But yes, I would effectively end. Now, in the law, we refer to this as a novation. The problem is there are different parties in the second one, and so it's arguable that it was not properly done. And so I would just skip that argument and just definitively terminate and definitively start a new one. I've talked over and over about the Texas Realtors lease. It's a very popular lease and very common throughout the state. I'm not going to get into all of the strengths, except to say it's an excellent lease. It's an excellent lease, and a lot of people use it because it's a tried and true document that's seen lots of court time. But I will point out one problem that I have with it when it comes to the automatic renewal provision. So the automatic renewal provision, I believe, is section 4 of the lease. It's on the first page, and it has some quirky language to it. So typically, people will elect for a 30-day notice on the termination of that lease. So that by definition, the lease will automatically renew for a month-to-month tenancy, even beyond the stated term, unless landlord or tenant give notice in writing at least 30 days in advance of their intent not to renew, or once it has lapsed into a month-to-month, their intent to terminate. Very clean. But there's a second provision on the second page that so often is left blank, and the parties don't elect, or they elect the wrong one. And what it says is either A, the notice is effective 30 days from the date of the notice, or it's effective on the last day of the subsequent month in which notice was given. Which means if you are in the middle of November and you give a 30-day notice and you've selected the first option, then exactly 30 days from now, the lease terminates once you're on a month-to-month. Or if it's the second option, it doesn't end until the last day of the next month, which would be December. Where it gets wonky is if you're asking for 45 days or 60 days, especially if it's 60 days, because if you gave a notice in November, there's no way that 60 days could lapse between now and the end or the last day of the subsequent month, December, unless I gave it on November 1st. That's the only way that it works. And that's not usually how it works. And so people are very confused. It's an ambiguous term. And what we know about the law is that when there's an ambiguity in a notice or a document, that ambiguity is resolved in favor most for the non-drafting party, in other words, the tenant. And sometimes landlords unknowingly put themselves in a tough position because of that clause, and they miscount the days. And so I don't like that. I don't like the way they worded it. I also don't like the sublet option in the lease. I think sometimes tenants see that and they exercise it. I cut that out of my lease. I don't allow subletting unless that's what the landlord is doing for whatever reason. I think it's a bad idea. And then finally, the issues of early termination. There's a section in the Texas Realtors lease that calls for it. I prefer to handle it on a case-by-case basis. And so when I advise landlords, I tell them, look, you're better off not mentioning early termination, number one, to ensure that the tenant stays throughout the term or is on the hook all the way to the end. But number two, if you do have to enter into some kind of agreement, that you make an agreement that makes sense for your property at the time in your market. So just a few things. Otherwise, and again, these are not everyday sorts of problems, but otherwise it's a very strong lease. It's a very strong lease. Again, with a few quirks. So let's talk about all of these damages. Now, first of all, I don't know what your lease says. I don't know what the damages are, and I don't know if they gave a forwarding address. But I want to assume they gave you a forwarding address. And I also want to assume that the lease goes on beyond December. Does the lease? When is the actual termination of the lease?
Let's go to month to month.
Well, month to month means you're limited. So if they left in October or they left in November?
They left on October.
They left on October. Then your damage calculation stops at the end of November. You were only ever allowed 30 days of rent. And so once they left in October, the maximum you can get in unpaid rent is November. So if they didn't pay October and they didn't pay November for rent damages, that's where you're limited. 2 months of rent, plus whatever the material damages to the property, that's your total damage calculation. If there had been more months, the facts would be a little bit different. You might have the ability to capture additional damage, but for now, on a month-to-month tenancy, that's where you're limited. You can only get rent for the following month. Now, as far as the itemized list of damages, technically, because they left still owing rent for November, they're not entitled to an itemized list of damages. But I would strongly suggest that you send it, especially if they gave you a forwarding address, because they might try to sue you anyway. This happens a lot. When someone without a rightful claim to their deposit sues you and says, well, I read that I could sue you for 3 times those damages plus $100 and all of my attorney's fees. And that's exactly what I'm going to do. And that's exactly what they do. And now you have to lawyer up and go and defend yourself just to win against a tenant who can't pay your bills. Not a good position. So I would get ahead of it. I would send that notice to them and say, your security deposit went to unpaid rent and these damages, and be done with it. I would list the damages first.
Yes.
So you damaged X, Y, and Z at this value, and be prepared to demonstrate that to a court in a future lawsuit that I paid X, Y, and Z for these damages. Be able to prove that, and then say, plus you owed rent for October, and you owed all of the late fees for October, and you owed rent for November, and you owed all the late fees for November, and maybe I had reletting costs or whatever. Everything you can charge, put it on there. If it's $10 million, make sure you can justify it, but then you list it.
Yeah.
Don't leave it off because, well, I got tired of writing so many deductions. Put them all down. Because I guarantee you, if you don't, and then later a judge says, well, these are not valid, and you think, well, if I had just put all of them, I would at least have had enough to cover the security deposit. Never leave off valid deductions. Never, never, never. You can request it all you want. Whether you'll get it is not what's important. Whether you have sent notice of the deductions is ultimately what's important. Did you notify them of how the deposit was spent? You have 4 years to sue them, but you only have 30 days to give them proper notice if the court says they're entitled to it. I would always assume that that's the case.